So you were fired, or you think you might be getting fired. For most Americans, that means that not only did you lose out on a source of income, but you might also have lost your family's health insurance. That is naturally not ideal. And if your state does not have a good faith employment exception, like 39 of the states don't, you are an at-will employee. But you may have a case for wrongful termination. In this episode, we're going to talk about what it means to be wrongfully terminated, how to make a case, what a case looks like, and what to look for in an employment lawyer. Hi, I'm attorney Doug Mann, and I'm a managing partner with Dyer, Garofalo, Mann & Schultz. Our law firm practices employment law in Indiana, Kentucky, and Ohio. People are fired every day. It's never a pleasant experience, and a few people ever walk away from it being happy. But it doesn't generally mean that anything illegal has happened. All states are technically at-will employment states. That means you could be fired for any reason or for no reason at all, provided they don't give you a reason that's illegal. Most states have some additional exceptions. The most common is public policy, which we'll get into later. But at the moment, only 8 states don't have this in place. There's also an implied contract exception. 14 states don't currently have this in place. This is probably the hardest one to prove, and it puts all the pressure on the employee to have the evidence that a contract was implied in the first place, which is why we always recommend trying to get everything in writing. Keep all of your emails from when you're interviewing for a job, and definitely hold on to the job description you applied for. Implied in law exceptions are a little more rare. Only 11 states have this one. It basically means that the company can't fire you to avoid paying retirement benefits or other such sketchy behavior. Determining if a firing was illegal could depend on the laws in your state. 11 states have goodwill exceptions that require employers to provide a good reason when firing an employee. But for the most part, it will fall under one of 9 different categories as an at-will employee. Public policy violations is a massive category for wrongful termination, depending on the state you live in. This type of wrongful termination is based on the public policies created either federally or through the state. Taking time off to serve on a jury, for example, would be an illegal way to fire someone as it's protected by the federal government. Retaliation is one of the most common forms of wrongful termination. This is when an employee does something that is legally protected and an employer fires you in retaliation. This could be filing a complaint with the Equal Employment Opportunity Commission, reporting someone for sexual harassment, or whistleblowing on an illegal activity. This form of wrongful termination has 3 parts in court, though. You must prove that you were engaged in a legally protected activity. The activity prompted your employer to act, and your employer's actions had an adverse reaction for you. Like being fired. No matter what state you live in, discrimination based on race, national origin, sex, religion, age, disability, or pregnancy is illegal. The problem you may run into is proving that the firing was discriminatory. Your employer in an at-will employment state could fire you for having the wrong shoes on. Evidence of discrimination before the firing, or your employer using discriminatory reasoning for your firing, is where the wrongful termination cases come in. Another issue is that many states define sex differently. In some states, their definition is the only thing preventing the discrimination of both sexual orientation and gender identity. Those were the top 3 types of wrongful termination, but there are many reasons your firing could be unlawful based on the laws in your state. Implied contract is an exception that many states have in place. This exception recognizes implied promises and written promises. Written and implied promises are something you should always keep documentation of. If you have proof of job security, either written or implied in your contract or through other promises made before you started, it would be illegal to fire you. Another exception we talked about was the good faith exception. This recognizes the wrongful termination type, breach of fair practice. This means that your employer has done something ethically wrong by firing you. This can include firing you to prevent you from collecting commissions, misleading you about promotions, fabricating your reasons for termination when they had really hoped to replace you with someone willing to work for less money, or making your work life harder to coerce you into quitting. Defamation of character might be another reason for wrongful termination. If your employer made false statements about you that caused you to lose your job or lead to not finding another position, you may have a case. Though you should be aware that defamation can be really hard to prove. You need evidence that the defamation happened, that those statements were false, and that they led to you losing your job. The last type of wrongful termination is whistleblowers. Some states have different laws on this, and it does kind of fall under retaliation. When you report your employer for a crime they committed, you are still legally allowed to maintain your job, though there are some limitations. In some states, your job is protected if you reported them for a violation of any law, regulation, or ordinance, provided they were guilty of the crime, and other states only allow whistleblowers to report on labor or environmental laws. So you're pretty sure that you were wrongfully terminated. So what do you do next? That's where a lot of cases end right there. Talking with a lawyer can feel uncomfortable to a lot of people. Plus, how do you find a lawyer that handles wrongful termination anyway? And what if they don't take my case? No worries. Let's walk through the steps. For example, John got his first sales job. He knows nothing about sales and has made that clear before he starts his job. His employer said that he would be fine as all employees are given a 3-month training period where they're guaranteed job security until they get an evaluation after that training period. Amy is John's new sales manager. She doesn't think John's got his head in the game. He's far below the quotas of the other hires. John has only worked with the company for 1 month at this point. On the 2nd month, Amy calls John into her office. John hasn't reached his quota again, and Amy has decided to let John go. But John has evidence that his firing was a wrongful termination. His contract states that he has job security until after his 3-month training period, and he only worked at this point for 2 months. John tries to explain the situation to Amy and later to the HR department, but both blow off his concerns. John has medical bills to pay for the following month and worries he will miss a payment with his gap in employment. That is when John decides he wants a lawyer. John needs to find an employment lawyer for his case. Employment lawyers handle wrongful termination, harassment, discrimination, and sometimes workers' compensation claims. He can start the process by talking to a few firms over the phone. It's important that he finds a lawyer that not only has experience with cases like his, but that he gets a free consultation and that they work on a contingency fee. The consultation will get him an in-person meeting with a lawyer so that he can determine that he has enough evidence for his case and if that firm believes they can win the case. The contingency fee just means that he won't have to pay for the lawyer unless he wins his case, and it will only be a percentage of what he won in his settlement. A court case like John's can be pretty straightforward from there. Since John has evidence that he was wrongfully terminated, he will most likely be able to settle the issue outside of court with the help of his lawyer. Although most wrongful termination cases are settled outside of court, some cases still have to go through the court process. And the better evidence you can provide, the easier that case will be for you. The last step, your settlement. There are 4 things that might be considered in how much you end up with or receive in your settlement. The amount you lost in wages and benefits from losing your job, emotional distress and anguish, your legal cost, and sometimes, if the actions of the company were especially underhanded, punitive damages. And that's a rundown of your rights and the actions you can take after a wrongful termination. If you have any questions about employment law, just shoot us a question below this video. Want to learn more about your rights and how legal cases work? Hit subscribe.